which is two sentences. A federal court shuts the door today on a bid by a key Trump ally to derail the Georgia election interference case against Donald Trump and his allies. The 11th Circuit Court has denied a request by former White House Chief of Staff Mark Meadows to move his case out of Fulton County and into federal court. Over the last few months, Meadows has been arguing that the actions he took, actions that prosecutors allege are crimes committed in order to overturn an election, were things he did in an official capacity as a federal official, as a White House Chief of Staff. That argument was soundly rejected in court after court after court. And now the only recourse Meadows has left is to take it to the United States Supreme Court. Now, here's why getting the case moved matters to Meadows and perhaps more importantly to Trump and the other co-defendants in the sprawling Georgia RICO case. Washington Post reports this. Meadows had hoped a move to federal court could lead to a quick dismissal of the case against him because, as he argued in district court, as a federal officer, he is immune from prosecution for acts taken in the course of his normal work. Another potential advantage of the move would have been the slightly more Republican-leaning jury pool of the 11th Circuit when compared to Fulton County, Georgia, which is home to Atlanta. The Washington Post adds this, quote, the decision could bode poorly for 4 other defendants, all of whom are also seeking removal of their cases to federal court. Let's bring into our coverage former lead investigator for the January 6th Select Committee, Tim Heaphy, who's with us at the table, and New York Times Washington correspondent, MSNBC contributor Mike Schmidt. MSNBC analyst Barbara McQuade is still here, former U.S. attorney and author of the new book, Attack from Within, How Disinformation is Sabotaging America. It's harder to pretend I don't know you now that we show everyone baby pictures before we talk about the news. I'll start with you on Mark Meadows. And we talk about George Terwilliger, his attorney, almost as much as we talk about Mark Meadows. This is, and maybe this is unfair, but this is another legal defeat for that team.
Yeah, and I don't know what Meadows does now. I mean, that's what I would be interested in. Like, where do you turn at this point? Do you have to go to trial? I mean, what happens? I mean,
yeah, you have to eventually face the music and go to trial. He might file an appeal to the Supreme Court. I can't imagine that the Supreme Court would take this case. They take cases if there's a split in courts below or there's a close question of federal law. There's neither here. I think they would summarily deny a cert petition, and ultimately Meadows will face the music with a trial presentation in state court in Atlanta. That's where this is headed.
So that's why this is so frantic on his part?
It is yet another attempt to forestall that day, to keep the clock running so that he doesn't have to actually have it expire and be sitting in the defendant's chair in that courtroom in front of a jury. It's the playbook for all of them. Yeah. Without a really substantive defense, delay, 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 hope that something happens that will make the charges go away. But I don't think that's going to happen.
I can't help but think about Meadows' importance to the investigation. And actually, I was wondering, I think you've talked a little bit about this, but how important were Meadows' text messages when you guys first got them? And if Meadows were to ever really cooperate, what doors does Meadows unlock that we have not been able to see into?
The first question, Mike, very important. It gave us a sense as to who the president was talking to. It gave us a sense of sort of the real-time conversation about their belief that these rebutted theories of election fraud might continue to somehow be persuasive. So they were crucial to us in terms of leading us to other witnesses and giving us a sense, again, of sort of the state of rhetoric about election fraud. If he were to truthfully cooperate, it would be tremendously important. There was no one closer to President Trump over the course of the time between the election and the inauguration than Mark Meadows. He was in the room when it happened all the time. Now, he said lots of things to different people. He would say to someone, no, you know, he's coming around and we're going to get him there. He's going to cooperate with a transition. And then he would say, you know, in those text messages, keep up the faith and the fight continues. You know, I saw a clip today of Donald Trump Jr. putting his arm around Meadows on January 6th saying, this guy's a fighter. So depending on his audience, he would say different things. So there's credibility issues there, candidly. But if he were to truthfully cooperate, he would be tremendously important to Jack Smith or to Fani Willis.
Is there a scenario? I mean, so much of what we cover, and I'm acutely aware of this having been away and back, and we're still having some of the same conversations. But is there a scenario where all of his legal efforts fail and a floodgate opens. I mean, it seems that if you're arguing you did these things in your official capacity, you're arguing that Donald Trump told you to do it, and you're a very bad and dangerous witness to Donald Trump.
Absolutely. Yes. Look, a lot of criminal defendants, Nicole, will, the ones that sometimes seem like the least likely to cooperate, the ones that are holdouts, once there is no other door to knock upon, once they're all closed, they become really important cooperators. Because again, that same strength, that same fidelity to purpose, when it's flipped and the door opens to cooperation, it could be tremendously important. Maybe Meadows is in that category. There's some reporting that he has been debriefed by the special counsel, that he says he repeatedly told the president that these theories of election fraud that he's saying publicly have no merit. If he were to testify to that, that would be very direct evidence of the president's state of mind, which is the whole ballgame in the special counsel's case.
I want to bring Barbara McQuade into this. Barbara McQuade, I know we are awaiting a lot of things from the Supreme Court. One of them is for them to decide whether to look at Trump's immunity claims and belief that presidential immunity renders him somehow harmless and not liable and not exposed to any criminal prosecution for trying to overturn an election. What is your sense on the timing of any of that?
It's really curious to me how much time has passed, because in light of the fact that they decided this case to hold the hearing in this case on an expedited basis, the fact that we're still kind of waiting around to hear what the result of this is a little bit perplexing to me. It strikes me that what the court below decided in the D.C. Circuit Court of Appeals, rejecting this immunity defense, is very sound. And I have to think they've got, I don't know, at least 6 or 7 votes that would agree with that. It makes me curious as to whether someone isn't perhaps writing a dissent from that. And so perhaps one of the more conservative justices disagrees with that proposition, or perhaps more optimistically, Chief Justice Roberts is trying to build a consensus to get everybody on board because he wants to send a strong message that the president is not immune from criminal prosecution. So whatever it is they're doing, I wish they'd get on with it.